This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Gary, you noticed I'm back.
You're back in California. This is a monumentous occasion. I might actually get to see your smiling face. It's been before
with any luck, I'll be in the office sometime tomorrow afternoon after my journey. By the way, I told you've heard this story about this case, but many listeners have heard it over the years. I just got back from a trial in Arkansas. This was the case that's been dismissed twice. I've gone to the Eighth Circuit Court of Appeal twice. It's been reversed and published decisions twice. Finally, on January 29th, we were set for trial and we started picking a jury. And I did the closings on Monday. We're taping this on Sunday. We did closings in the morning, and jury came back it's because there was no Friday involved. They came back in the afternoon.
Right.
I think at 10 of 5 o'clock, 4:50, and awarded. I'll tell you, there's nothing like verdict, whatever, and the judge says to the foreperson, $15 million, and she said, "Oh yeah." Then the next verdict, another $15 million. Oh yeah. And then by that time, I was in.
Yeah, a different state of mind. I was watching from afar, and I got to tell you that I actually learned of the verdict before you even got to me, and I just could not possibly be prouder of you and happier for the family. It is a wild verdict.
$32 million. They ended up hitting the chief of police, the city of Benton, Arkansas, as they should. I mean, it was the trial went, we tried that case basically in a week, started on a Monday, verdict the following Monday. And kudos to Kim and Casper and to Satara, who actually flew out to Little Rock with her baby Delilah.
Yeah.
And I spent mornings and afternoons in the courthouse and evenings with Delilah at the various restaurants in Little Rock. And
Delilah is just adorable. I've met her, and she's absolutely a beautiful child. And kudos to Satara for sure, because traveling with a child that age and being able to sustain that as a mother while doing your job is it's almost like doing 3 jobs. So
it was something. I will regale you with more when I see you tomorrow, but an 8-year slog, and the jury did the right thing, came back with $32 million.
Well, congratulations to you and your clients. It's a hard fought victory that is well deserved, and I couldn't be happier for everyone involved.
Thanks. And while I'm doing that, boy, what I've said before, that as the geek that I am, I enjoy listening to or watching, if it's a circuit court that's got the video. The Supreme Court only has the audio, and district court. Apparently in my trial in the district court there, they had a closed circuit, and I received some feedback from people who were watching, but you can't access that from the outside. The federal courts have a much more limited camera opportunity than the state courts do. But I told you that we were listening to the case that was just argued this past week, Thursday, I believe, right, Gary?
Correct.
And it was Trump versus Anderson. It's where the district court in Colorado ruled that Trump had been involved in an insurrection, but that the office of the presidency was not covered by Section 3 of Article 14, and declined to take him off the ballot. Went to the Colorado Supreme Court, where in a 4-3 decision, they took him off the ballot. For those who ask, there's 2 ways to get to the U.S. Supreme Court. One is you exhaust and go to a state Supreme Court, and you can go from the state Supreme Court to the U.S. Supreme Court. The other way is, for instance, if in my trial, Benton appeals and they go to, like they have twice before, to the Eighth Circuit, then you can go from the Eighth Circuit in the federal system to the U.S. Supreme Court. So anyway, this was in front of the U.S. Supreme Court, to give you a little background, if he's removed from the ballot before Super Tuesday, that changes the calculus of everything. So this is on a very fast track. It would never get, U.S. Supreme Court would not grant cert, which is what the term is, in a case like this and hear arguments this quickly. This is at warp speed for the U.S. Supreme Court. They have not ruled yet as we are taping this on Sunday. However, a number of people who listen to this are prognosticating it will either be 8-1 or 9-0. By the way, Gary, before we ever listen to this, many, many episodes before, we talked about how this was at least to my mind, the U.S. Supreme Court was not going to let this stand. We still haven't seen the ruling. Nothing about listening to this gives me any belief that they're going to remove Trump from the ballot based on this argument.
Yeah, we've been prognosticating that it might be 8-1, 9-0 for, months now. It's been, I think, at least 16 weeks since we started talking about this. And I agree. I listened to a large portion of the arguments, and I think that, if anything, I've moved closer to 9-0 than 8-1, because even the arguments against in the oral arguments from the justices, the questions against Trump's lawyers, although, intelligent.
By the way, I will, if you like, I'm not second guessing, because I've been second guessed so many times in my career, but the lawyer, I will just say this, the lawyer for Trump, I thought Jonathan, is it Mitchell?
Yes.
I thought he did an outstanding job. I think he was a former Solicitor General in Texas. He came ready. Let's listen to I think we've got one clip of him with Sotomayor, who's the one that everybody keeps prognosticating may be the dissent.
You want to start with the Sotomayor question?
Yeah, I think so, because that's for those who want to hear what the opposite side argument is from what I think is going to be the majority opinion.
Phrase and Griffin's
right, you are, because it's not.
That's right. And okay, Griffin's
so now the question is a very different one in my mind. I understand what you're relying on, Griffin. Let's just be very clear.
Right.
Griffin was not a precedential Supreme Court decision.
That's correct.
All right. It was a circuit court decision by a justice who, when he becomes a justice, writes in the Davies case, he assumed that Jefferson Davis would be ineligible to hold any office, particularly the presidency, and treated, and this is his words, Section 3 as executing itself, needing no legislation on the part of Congress to give it effect. So you're relying on a non-presidential case by a justice who later takes back what he said.
But the key point with Griffin's case and why it's an important precedent, despite everything Your Honor said, it is not a precedent of this court. But Griffin's case provided the backdrop against which Congress legislated the Enforcement Act of 1870 when it first provided an enforcement mechanism for Section 3.
It did away with it later.
It did away with it later. But
that has nothing to say with respect to what Section 3 means. Can we get to the issue?
Yeah, so it's interesting. So what Sotomayor is saying is that the precedent that is being cited is this case that was authored by a justice, but it was when he was writing the circuit court back in the day. They used to go and do double duty, if you will. And then he famously wrote, when he was on the issuing a Supreme Court opinion in regards to Davies, who was the head of the Confederacy, that he had assumed under the Insurrection Act or not the act, but under the definition of insurrection, that he would be ineligible. Interestingly, that is not precedent, and that cuts both ways. Trump's lawyer, Mitchell, is arguing that it's precedent, which means it's binding. And the irony here is this court that's never stopped them before. Check Heller and check Dobbs. But they're arguing that it is not precedent. He concedes that it's not precedent. But it does go to the issue as to a secondary issue. Maybe you'll play this in one of these clips as to whether Congress needs to enact legislation to give import to Section 3 of Article 14.
Yeah, absolutely. Why don't we go ahead and play the arguments here, the opening statements of Jonathan Mitchell. I think those will set the table here a little bit. So here is the first clip.
Mr. Chief Justice, and may it please the court. The Colorado Supreme Court held that President Donald J. Trump is constitutionally disqualified from serving as president under Section 3 of the 14th Amendment. The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons. The first reason is that President Trump is not covered by Section 3 because the president is not an officer of the United States, as that term is used throughout the Constitution. Officer of the United States refers only to appointed officials, and it does not encompass elected individuals such as the president or members of Congress. This is clear from the Commissions Clause, the Impeachment Clause, and the Appointments Clause, each of which uses officers of the United States to refer only to appointed and not elected officials.
By the way, that is, to my mind, where they will go. Because it's so clear, I think, in terms of the idea that when you look at the text and you analyze the text of the Constitution, the issue is that you can't get in the way, or you, absent congressional legislation that would allow you to do it with a elected official, that this only applies to appointed officials, and that officer, if you read the text, would not encompass the president, because obviously the president is an elected office.
Yeah, and that absolutely seems to be where they're leaning the hardest, but they do have another argument that they are leaning on as well. So let's check this second clip out. This is the end of Jonathan Mitchell's opening.
The second reason is that Section 3 cannot be used to exclude a presidential candidate from the ballot, even if that candidate is disqualified from serving as president under Section 3, because Congress can lift that disability after the candidate is elected, but before he takes office. A state cannot exclude any candidate for federal office from the ballot on account of Section 3, and any state that does so is violating the holding of term limits by altering the Constitution's qualifications for federal office. The Colorado Supreme Court's decision is no different from a state residency law that requires members of Congress to inhabit the state prior to Election Day, when the Constitution requires only that members of Congress inhabit the state that they represent when elected. In both situations, a state is accelerating the deadline to meet a constitutionally imposed qualification and is thereby violating the holding of term limits. And in this situation, a ruling from this court that affirms the decision below would not only violate term limits, but take away the votes of potentially tens of millions of Americans.
Hey everybody, what's up? It's Gina Grad. And when you're searching for the perfect piece of jewelry, it can be hard to find a brand you trust. Alex and Ani has been creating meaningful jewelry for over 20 years, designing pieces that connect you with all of life's important moments. With an emphasis on value, there is truly something for everyone. They've recently launched their everyday collection. I could not love it more. These pieces are made from stainless steel and an advanced water-resistant plating method that doesn't tarnish. It has the look of real gold. It's beautiful. I love these pieces because they feel so classic, but they have so much versatility. Alex and Ani are also featuring some gorgeous pieces that I have right here, like Black Lotus, this gorgeous Black Lotus charm necklace, and their Stay Wild pendant, and their Wings of Protection necklace that have a classic and vintage feel. See that? And of course, you can't forget their signature bangle bracelets, which I'm also wearing. And I have a lot of their stuff. I have the numerology bracelets. I have the hula dancer to commemorate a meaningful trip I took to Hawaii. From classic to bold statement pieces, Alex and Ani makes it easy to sprinkle your personality into each piece or make a truly meaningful gift for someone you care about. Meanwhile, you can take comfort in knowing that you're shopping with a socially conscious brand, as Alex and Ani has donated over 60 million to nonprofits worldwide, connecting fashion and philanthropy in an easy, fun, affordable way. Right now, Alex and Ani is offering our audience 20% off. So check their gorgeous collection out at alexandani.com and use the promo code MIDAS. That's MEIDAS at alexandani.com. Use that promo code at checkout for 20% off your order. Come and get something beautiful.
So the argument there is that the Constitution lists what the requirements are. A state cannot insinuate themselves prior to the election to say we're going to add another layer as to what the requirements are. That would be verboten under, as he says, under term limits. It's also not a strict reading of the Constitution, and you can't do it. There's nothing that prohibits the running for office. The question becomes whether you can hold the office.
Right. And we also have a couple more clips here if you'd like to look at them. There's two from Ketanji Brown Jackson, who is questioning. These are interesting to me. So let's play the sequentially, and I'll comment in between. Let's hope that I got these right.
The Colorado Supreme Court concluded that the violent attempts of the petitioner's supporters in this case to halt the count on January 6th qualified as an insurrection as defined by Section 3. And I read your opening brief to accept that those events counted as an insurrection, but then your reply seemed to suggest that they were not. So what is your position as to that?
We never accepted or conceded in our opening brief that this was an insurrection. What we said in our opening brief was President Trump did not engage in any act that can plausibly be characterized as insurrection.
All right, so why would this not be an insurrection? What is your argument that it's not? Your reply brief says that it wasn't because I think you say it did not involve an organized attempt to overthrow the government. So that's
one of many reasons. But for an insurrection, there needs to be an organized, concerted effort to overthrow the government of the United States through violence. And this
so the point is that a chaotic effort to overthrow the government is not an insurrection?
No, we didn't concede that it's an effort to overthrow the government either, Justice Jackson. Right? None of these criteria were met. This was a riot. It was not an insurrection. The events were shameful, criminal, violent, all of those things, but it did not qualify as insurrection as that term is used in Section 3.
Thank you.
Thanks.
The reason I'm smiling is hearkening back to Little Rock, the chaos and chaotic became kind of a theme of that trial, that basically the city of Benton created this chaos, and that's why my poor client was executed. And here, she rightfully, I think that's a good point that the justice makes, that that don't stand on this idea that it has to be organized. If I had a nickel for every time I'd had a prosecutor who brought a conspiracy case and said, you made the argument that the organization one part doesn't have to know what the other is doing, that it's just a conspiracy. I mean, that's a good point. But Mitchell, to his credit, came right back with it. He embraced the fact that it was violent. He embraced the fact that it was shameful. He didn't run away from that. He didn't try to redefine it. And I thought, and I think by listening that, you would think that she would be the logical person to form a dissent with Sotomayor. But listen to the next clip.
Yeah, absolutely.
I'm trying to understand the distinction between the provision in the Constitution that relates to disqualification on the basis of insurrection behavior and these other provisions that Justice Sotomayor points out. They all seem to me to be extant constitutional requirements. So, but you're drawing a distinction.
Right. I'm drawing a distinction because some of them are categorical.
What do you mean by categorical? Whether or not you are an insurrectionist is or is not categorical?
It is not categorical because Congress can lift the disability by a 2/3 vote.
But why does that change the initial determination of whether or not you fall into the category? I don't understand the fact that you can be excused from having been in the category. Why does that not make it a categorical determination?
Because we don't know whether President Trump will be excused before he's sworn in, if he wins the election, on January 20th, 2025.
Yeah, it's a good point, and they're trying to, and the categorical distinction. So you understand there is support for the fact that even if you don't, the difference between running, getting elected, and then Congress potentially stepping in between the time of the election or being sworn in and removing a disability is what they're talking about.
Right. And it's, it was interesting. A lot of people are kind of jumping on the fact that in that, not the most recent clip, but the second to last one that we played, that Trump's lawyer was conceding that it was a riot, trying to recategorize it from an insurrection to a riot. It's he talks about that a few times, and it's
and by the way, if you're up there and you're arguing, why are you going to inflame those that you are arguing by a point that ultimately at the end of the day detracts from the argument itself? He's trying to make the argument that the textual reading of the Constitution does not allow for what the Colorado Supreme Court did. The categorization and the fight, and I use categorization not to refer to what they were just talking about, but the labeling, how about that, or
sure,
giving it a nomenclature of insurrection or not. That is a sideshow for the main thrust of the two arguments here. So why get into that? What he does is he basically sidesteps that because from his standpoint, it doesn't go to the main issue.
Yeah, absolutely. It's, it's fascinating. And I think that we're going to get a ruling long before our next episode. So we will definitely be watching, and we will cover that next time we speak. Mark, I am so happy to see you back in California. It is wild to think that it was before the Los Angeles Magazine sponsored DH debate that you departed us. And I will look forward to seeing your smiling face tomorrow at the office.
I'm happy to see you too, Gary. Thank you. Thank you, everybody, for joining us on Sunday. Wait, Gary, comment of the week. You're going to get out of here as you're wearing the swag? Didn't I send you the comment of the week?
The comment of the week, I think you sent me last week's, the gentleman who I have his name here somewhere, but
shared the Odar heritage.
The Odar heritage, exactly. That was the gentleman. He got in touch with me.
I have a new one that I saw. And I will send to you, and so we'll announce two. You can double ship next week. And it was a very kind comment. I kind of embraced the one who said, "I really have nothing negative to say." It was refreshing on a Sunday morning. Yeah. I felt here on Lenten Eve that gave me kind of a little wind at my back going into Lent.
Yes, absolutely. So we certainly enjoy it.
I know you don't look at them, so I'll look at it, I'll find it, and I'll send it to you. But whoever it was that said, "I've got nothing bad to say," you're the winner.
All right. And you can email me your information and take a picture of yourself logged into YouTube for verification. reasonabledoubt1942@gmail.com. And everyone who has been picked, we have been waiting Mark's return so I can figure out exactly how to figure out the shipping infrastructure here. So everything will start to go out this week. So look forward to your packages coming soon. And thank you all so much for listening. Follow us on YouTube, youtube.com/reasonabledoubtpodcast. And thank you all so much for your support. Mark, I look forward to seeing you soon, and we will see you all next Sunday.
Thanks, Gary. Bye-bye.
Bye-bye.
Thanks for listening to Reasonable Doubt. Subscribe on YouTube at youtube.com/reasonabledoubtpodcast.